A new ATF rule carried an official start date this month, and dealers were already preparing for the change. Then the date arrived, the rule disappeared, and the old requirement stayed in place. So how can a federal rule have an effective date and still never become law? To understand how a printed date can simply evaporate, you have to go back to the last week of April 2026. In a single coordinated announcement, the Department of Justice and the Bureau of Alcohol, Tobacco, Firearms, and Explosives released 34 separate rulemaking notices, not 34 minor corrections buried in an agency newsletter. 34 actions touching background checks, dealer licensing, import procedures, firearms record-keeping, and the National Firearms Act itself. The agency called it a new era of reform. It followed a presidential executive order, numbered 14,206, directing the Justice Department to review federal firearms regulations. ATF sorted the 34 actions into 5 categories: repeal, modernize, reduce burden, clarify, align. Inside gun shops from Texas to Pennsylvania, the reaction was immediate. Screenshots of Federal Register pages circulated through group chats. Headlines announced that braces were legal again, that record-keeping requirements had been rolled back, that traveling across state lines with a registered firearm no longer required approval. Some of that was accurate. A surprising amount of it was not. And the gap between those two categories is exactly where gun owners get themselves into trouble. Because in federal rulemaking, the phrase new ATF rule describes 4 fundamentally different things. The first is a final rule. This is regulation with full legal force. It has been through the process, it carries an effective date, and on that date the language inside the Code of Federal Regulations physically changes. A final rule binds you, it binds your dealer, and it binds the ATF inspector walking into a shop with a clipboard. The second is a notice of proposed rulemaking, usually shortened to NPRM. This is the agency telling the public what it would like to do and asking for reactions. A proposal is not law. It does not change a single word of the existing regulations. You can read a proposal announcing that a requirement will be eliminated, and that requirement will still be fully enforceable against you the following morning. Many of the 34 notices from April were proposals, and most of the arguments you have seen in comment sections trace back to somebody mistaking one for a final rule. The third is an interim final rule, which takes effect while comments are still being collected. Rare and usually reserved for urgent or narrowly technical corrections. The fourth is the one that explains our opening mystery. It is called a direct final rule, and it is the most misunderstood instrument in the entire federal regulatory toolkit. A direct final rule is what an agency issues when it genuinely believes nobody will object. The agency publishes the change, prints a future effective date on it, and attaches a condition. If anyone files what the law calls a significant adverse comment before a stated deadline, the rule is pulled. Not delayed, withdrawn. That is precisely what happened with the rule scheduled for August 4th. The subject matter was mundane. Under long-standing regulation, when one federally licensed dealer transfers firearms to another licensed dealer, the sending dealer must obtain a certified paper copy of the receiving dealer's license. ATF proposed letting dealers verify one another electronically instead, through a free public database the agency already operates called FFL-EZ Check. The system is online, it is updated regularly, and dealers were already using it informally to sanity check a license before shipping a rifle across the country. ATF published the direct final rule on May 6th, effective August 4th, unless significant adverse comment arrived by June 5th. The agency clearly expected silence. It did not get silence. Adverse comment arrived before the deadline, and on July 6, 2026, ATF published a formal withdrawal, signed by Director Robert Cekada, pulling the rule entirely. The withdrawal notice stated the agency might revisit those provisions later through a standard proposal, addressing the objections it had received along the way. So the certified paper copy requirement stayed exactly where it had always been. A dealer in Ohio who stopped collecting certified license copies on August 4th because a headline back in May told him the requirement was going away would have been quietly building a compliance violation into every single transfer he made. That is the most important lesson in this entire subject. A printed effective date is a plan, not a promise. Now, some of the April package was very real, and it deserves the same careful attention. Consider the bump stock rule. Back in 2018, ATF had rewritten its regulatory definition of the term machine gun to sweep in bump stock devices. In 2024, the Supreme Court took up the question in Garland versus Cargill and held that a semi-automatic rifle equipped with a bump stock does not meet the statutory definition of a machine gun as Congress actually wrote it. That decision left the regulation stranded. The text sitting in the Code of Federal Regulations said one thing, and the highest court in the country had said something different. So ATF issued a genuine final rule, removing 2 sentences from 3 separate regulatory definitions and bringing the written regulation back into alignment with the statute and the court's holding. That is a real change to the rule book. It is also, importantly, a change that mostly ratified something the courts had already settled. Notice that pattern because it repeats throughout this package. Now compare that to the stabilizing brace situation, which is where the confusion ran deepest of all. A stabilizing brace is an accessory originally designed to help disabled shooters control a heavy pistol with one hand. In 2023, ATF issued a final rule creating criteria for when a braced pistol should instead be classified as a short-barreled rifle, which pulls the firearm under the National Firearms Act and its registration requirements. Millions of Americans owned braced firearms. The rule triggered immediate litigation across multiple federal circuits. Courts enjoined it, stayed it, and vacated it. By ATF's own written description, the 2023 brace rule was rarely actually in effect anywhere in the country. In the April 2026 package, ATF proposed removing the language that rule had added. Headlines announced the brace rule was dead, but read the label carefully. That action was a proposal, carrying a comment window that ran into early August. A proposal to delete text that courts had already largely neutralized is not the same event as a fresh grant of freedom, and describing it that way misleads people about what they can actually rely on when they walk into a gun shop. Set the withdrawn rule and the bump stock correction aside, and the proposals sitting inside that April package are where daily life for gun owners would actually change. Start with interstate travel. Federal law already protects a lawful owner transporting a firearm from a state where he may legally possess it to another state where he may legally possess it, provided the firearm is unloaded and stored properly during the drive. But the statute never defined how much stopping a single trip is allowed to contain. Owners driving a rifle case from Idaho to Georgia have spent decades quietly guessing whether an overnight stay at a roadside motel breaks that protection. ATF proposed writing the answer down. Under the proposal, activities reasonably necessary to travel would formally count as transport, including staying overnight in temporary lodging, stopping for food or fuel, vehicle maintenance, an emergency, medical treatment, or moving between modes of transportation. The proposal also addresses carrying ammunition and accessories across state lines, and how a firearm should be secured while in transit. A separate proposal targets registered National Firearms Act items specifically. Under current regulation, moving certain registered items across state lines means filing paperwork and waiting for approval before the trip begins. The proposal would eliminate advance approval for short-term travel of 365 days or fewer, while permanent relocation would still require notification. Another would allow married couples to register NFA items jointly without setting up a legal trust to accomplish the same result. Another, released in July, revisits the fingerprint and photograph requirements attached to firearms applications, with a comment period running into October, and one addresses record-keeping directly. A rule finalized in 2022 required licensed dealers to retain transaction records indefinitely until the day they discontinue business. The new proposal would replace that indefinite period with a defined one, and ATF published its reasoning in the document itself. In the first half of fiscal year 2026, roughly 89% of successful firearms traces required records less than 20 years old, out of more than 228,000 traces conducted nationwide. One more deserves mention because it reaches private sellers rather than dealers. A rule finalized in 2024 had broadened the regulatory definition of who counts as engaged in the business of dealing in firearms, and therefore who must obtain a federal license and run background checks. ATF proposed rescinding portions of that definition while keeping the language Congress itself wrote into statute. That statutory text does not move, regardless of what the regulation built around it does. Every single one of those is a proposal. Not one of them changed a requirement on the day it was published. One thing did change immediately, though, and it did not arrive through rulemaking at all. ATF ended an internal enforcement policy that had pushed inspectors toward license revocation for certain violations, replacing it with a new administrative policy emphasizing firearm traceability and public safety while de-emphasizing immaterial paperwork errors. Dealers whose licenses were revoked or surrendered under the old approach may now reapply. Internal agency policy is a fifth thing that can shift under your feet, and it moves faster than regulation, precisely because it never has to pass through the Federal Register at all. If this breakdown is helping you make sense of federal firearms regulation, subscribe. We cover the history, the engineering, and the legal machinery behind American firearms every week. And the next one builds directly on this. The most consequential development of this entire period, though, did not come from ATF at all. It came from Congress, and then from a federal courtroom in Texas. To understand it, you have to go back to 1934. The National Firearms Act was written during the Great Depression, in the era of Dillinger, the Kansas City Massacre, and Thompson submachine guns in newspaper photographs. Congress wanted to restrict machine guns, suppressors, and short-barreled firearms. But there was real doubt at the time about whether Congress had the constitutional authority to simply ban them outright. So lawmakers used a power nobody disputed, the power to tax. The National Firearms Act imposed a $200 tax on making or transferring a covered item, and it built a registration system to collect that tax. $200 in 1934 was an enormous sum, comparable to the price of a new automobile. The tax was the constitutional foundation. The registry was simply the collection mechanism sitting on top of it. That $200 figure was never adjusted for inflation. For 91 years it sat there, shrinking in real terms with every passing decade, while the registration requirement it supported grew into the defining daily reality of NFA ownership. Fingerprint cards, passport photographs, approval waits measured in months. Then, in July of 2025, Congress reduced the making and transfer tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons to $0. That change took effect on January 1, 2026, but the registration requirement stayed exactly where it was. Same forms, same fingerprints, same photographs, same waiting. The tax was gone. The paperwork built to collect the tax remained. That gap between a tax of zero and a registry that outlived it became the center of a federal lawsuit. On August 5, 2026, Judge James Wesley Hendricks of the United States District Court for the Northern District of Texas issued a final judgment in two consolidated cases: Silencer Shop Foundation versus ATF and Jensen versus ATF. The plaintiff group was unusually broad, including suppressor manufacturers, retailers, several national gun rights organizations, individual owners, and 15 states. The court's reasoning is worth understanding precisely, because it is not the argument the headlines predicted. The plaintiffs did not win on the Second Amendment. Those claims were dismissed without prejudice as abandoned. The court decided the case on enumerated powers, meaning the question of what authority the Constitution actually grants Congress in the first place. The holding was that because the registration and approval requirements were enacted under the taxing power, and because Congress had reduced that tax to zero, the constitutional basis for those particular requirements no longer supported them as applied to untaxed items. The court entered a permanent injunction, then stayed it for 7 days to give the government a window to seek relief from the Fifth Circuit Court of Appeals. The government did not seek an extension of that stay. When the 7 days expired at the end of August 12th, the injunction became operative. Here is where careful reading matters enormously. The court did not issue a nationwide injunction. It did not strike the National Firearms Act from the books. The order bars ATF and the Justice Department from enforcing the challenged provisions against the plaintiffs and, where applicable, their agencies, political subdivisions, members, and customers. If you are not inside that defined group, you are not covered by it. Living inside one of the 15 plaintiff states does not by itself place you within it. The order also had zero effect on state law. A federal court ruling about federal constitutional authority cannot rewrite a state statute. If suppressors were prohibited in your state before this decision, they remained prohibited the day after it. And as of the summer of 2026, an appeal window remained open. Attorneys following the case have been consistent on this point. A district court ruling is not the same thing as settled national law, and anybody acting on one needs to know exactly where they stand inside its boundaries. Final rule, proposed rule, interim final rule, direct final rule. The document states it plainly, near the top, under the heading Action. Every one of the 34 April notices carried that label in the same place. The information was never hidden from anyone. It was simply skipped. Third, treat state law as a completely separate wall. Federal deregulation does not touch it. There are states where a firearm configuration that is entirely lawful under federal rules will still carry serious criminal exposure, and the direction of federal policy has no bearing on that whatsoever. Check your own state's current statutes independently every single time, and remember that state legislatures move on their own calendars.